Well, hello, everyone. I hope each and every one of you are having a fantastic day. Matthew L. Thrift here with Brokering Different, one of the brokers here at Berkshire Hathaway Home Services, Sedan Joiner Realtors. Today's video is about the top 10 questions I get asked as a broker in charge. I'm going to break them down. I'm going to give you some great information, especially if you live in South Carolina. Stay tuned. Here it comes. All right, everyone, welcome to Matthew's Top 10. Today's video is about the top 10 questions asked to me by agents. We're going to jump right into this, but before we do, the disclaimer here is most of the answers shown today will be standard. They'll be standard answers. There are often times when the answer cannot be given by me, right, when an agent asks me, until I have to ask further questions in order to understand the full details of the question, right? So when I get these questions, sometimes I may have to break down that question just to be able to give that correct answer. But a lot of these answers are going to be standard. So we'll break those down as much as I possibly can. All right, no further ado. Number 10. Okay, what is a normal time frame for repair procedure? As you know, repair procedure is going away June 13th. So if you're listening after June 13th, this question is going to be null and void anyway. If you're dealing with a South Carolina Form 310 repair procedure, we're going to a due diligence contract. So again, after June 13th, repair procedure won't be here, neither will as is. But what's a normal time frame for repair procedure? Okay, so here it is. I've always said typically 10 to 12 days for the buyer inspection period, 3 to 5 days for sellers to respond in that paragraph 2, and then the contract automatically calls out for 2 calendar days for the buyer to decide what to do. It's pretty simple. If you need a little bit more time than that, depending on whether inspectors are busy or whatever, you may have to adjust that first line, maybe 12 to 14 days, but typically standard 10 to 12 day buyer inspection, 3 to 5 days for seller to respond, and buyer then has the 2 calendar days to decide what to do. All right, so number 9, what is a normal time frame for due diligence? For the due diligence, remember the difference between repair procedure and due diligence, there is only one date that buyer and seller need to hit, okay? One date. So my answer for that is about the same thing. It's going to be, you put that date in there and you got to account for about 10 to 12 day buyer inspection period, maybe 3 to 5 days for seller to get back to you, and give your buyers plenty of time to terminate that contract. The last thing you want to do as an agent is get that time frame right up to the point where it's 5:50 on that date of expiration of due diligence and trying to be scrambling, getting that buyer to sign that termination. That is going to be bad. Do not do that. I highly, highly, highly caution waiting to the very last minute. So again, adjust that date, that one date, for 10 to 12 days, for maybe it could be even 7 to 10, depending on how quickly your buyer can move. 10 to 12 days for inspection period, 7 to 10, 12 days for buyer inspection period, right? And then 3 to 5 days during the one time frame for sellers to respond. And then again, 2 or 3 days for your buyer to decide what they're going to want to do. So hopefully that answers that question. There's many other time frames that we could talk about here, whether a buyer wants to do an as-is contract with due diligence, by having a very, very short due diligence time frame with a high termination fee. That wasn't this particular answer. We can go on to that in another video sometime later. But as of right now, that's about what I would say when somebody asks me that particular question. What's a normal time frame for the due diligence period? Number 8. All right, number 8. What is the normal termination fee for due diligence? Notice I'm using the word normal. Let me stop and say there's no such thing as normal in real estate. It seems like every transaction, every buyer, every seller, terms, they're all different depending on what the transaction is, depending on the parties. So normal is very, very difficult. So there's no such thing as a normal termination fee either. I've seen no termination fees, and I've seen fees, typically at $500 to $1,000, $2,500. In other states, a lot of times it's larger. As we go into June 13th and beyond, we're going to start seeing maybe what can become normal, but it's really just going to depend on how much, this answer right here, there's not a normal termination fee. This is completely negotiated. How much is the buyer willing to pay to play? How much is that buyer willing to put up in order to be able to terminate that contract? So it's just going to be completely up to the buyer. So there's no normal termination fee. All right, number 7, what is the best way to write an offer in this market? What's the best way to write an offer? There's so many things that I can go into on this. However, let's look at this really easily. The best way to write an offer in this market is to break down what is important to the buyer and structure the offer with the most fitting terms for that buyer. Now, I say that and you say, well, it's going to have to do with the seller as well. That's exactly right. If you're working on the buyer side and you're writing an offer for that buyer, you got to find out what's important to them. And then, and what's necessary. Are they able to do an appraisal gap? Are they able to do an escalation clause if your buyer wants to do that? And I'm not pushing any of these particular terms. I'm just saying, are they able to do that? Are they able to put down more in earnest money? Are they able to put down more of a termination fee? It's just all going to depend. So how you're going to make your strongest offer. But you got to find out what's important to the buyer. And then I would go even further and say, we just want to have a discussion with the listing agent and find out what's important to the sellers as well. Are they looking for a long-term close? Are they looking for a short stay after they close? Well, there's all sorts of factors. So do your due diligence, so to speak, and find out as much as you can and structure the offer with the most fitting terms for that buyer and maybe even some for that seller as well. Number 6, how much money is normal to put down for earnest money? Once again, there is no normal. Do I see $1,000 a lot in earnest money? Yes, I see $1,000 more than any other number, but there's no normal, consistent answer for that. Okay, it just really all depends on the particular buyer. What are they able to put down in earnest money? Now, I will caution you, be cognizant of the $7,500 rule, which means if anything is written in earnest money over $7,500, if there is a dispute, buyer and seller would then have to go to magistrate's court. If it's under $7,500, you go to summary court to have an interpleader judge decide what would happen to that earnest money. But again, typically I see about $1,000 most of the time. Number 5, here we go. We're almost halfway through. My deal is falling apart. Parties are arguing over who gets the earnest money. When can I return the property back to active status? Okay, I can go into a whole lot of detail on this, but the easiest answer is if buyer and seller are arguing over earnest money, our new South Carolina Form 518 allows earnest money to be in dispute, but releases all parties and all brokerages from liability, and it terminates the contract, the Form 518. Okay, as soon as both buyers sign that, there's a box there that says the contract was released, but earnest money is in dispute. You can put the property back on the market once you get that back. Okay, now there's a whole lot of things that we can talk about. Is if a buyer puts in a termination, a Form 313 notice of termination, and maybe the seller didn't agree with them terminating. Maybe now the seller wants to litigate. I would be very cautious, and I would consistently say if a buyer wants to do that buyer, and possibly I would say even the seller, need to talk to counsel, because if that seller thinks that they defaulted on that contract and the buyer only puts in a Form 313, there's no 518 signed, that leaves a buyer up for possible litigation. And if there's litigation involved, I've always understood that has to be disclosed, that home, that contract is under a civil litigation, and you may not have to be, or may not be able to put that property back on the market if there is a lawsuit been filed, okay? But most of the time that doesn't happen. Most of the time, if only a notice of termination is done and there's an argument or whatever the case may be, the contract can expire. Once that contract expires, it becomes dead. The contract expires when it was originally going to close. I've always understood you're able to put the property back on the market after the expiration. Okay, that's the basic answer to that question. When can I return the property back to active status? When the contract expires and nothing has gone through, or a Form 518 has been written and has been signed off on, and the earnest money is in dispute. That's the easiest way to answer that question, right? And so there it is. It's unilateral, 313, one party. It's issued, the contract is terminated, can be placed back on the market. If no 313, the contract expiration, or the 518, which is basically summing up everything that I said. All right. So number four, if my buyer's home inspection comes back with something major, can they walk away and get their earnest money back? You do not know how many times I get this question. Listen, the answer is not that cut and dry. There's no automatic way for earnest money to automatically come back, okay? If you're in repair procedure, the buyer must go through the repair procedure time frames, okay? If something major comes back and the buyer gets cold feet, they still need to ask the seller to repair those. Now, they can go and do it on their own and terminate, okay? There's nothing stopping them saying that they can't, other than the way the contract's written. They could be found in default on that. I'm not an attorney. I'm not going to go down that road, okay? Because I'm not going to give legal advice, okay? But the way the contract's written, if they terminate, or correction, if they want to terminate during repair procedure, okay, they need to go all the way through repair procedure, ask for the seller paid repairs to be done. If and when a seller says that they're not going to do any portion of the 9 systems that were asked for, at that point, the third paragraph says the buyer can accept the property as is, renegotiate, or terminate the contract by notice. That's when they can terminate. If they're in due diligence if something comes back, obviously that's really easy because the notice of termination says you can cancel for any reason. Okay, if they find something on their home inspection, they can cancel, and the intent and the spirit of the contract is for that buyer to be able to get their earnest money back. However, there is no automatic. It has to be a release signed or agreed upon by both parties or by a court of competent jurisdiction. Okay. All right. So that's the answer to that question. Coming in at number 3, do I need a transaction brokerage agreement for a customer? Okay. So do I need a transaction brokerage agreement for a customer? Let me answer that this way. Here you go. All right. So our policy here at Berkshire Hathaway Home Services, Cedar and Joiner Realtors states that a transaction brokerage is only needed or required from the customer obligated to compensate you. So let's break that down a little bit. If you are helping a customer buyer purchase a for sale by owner property, which means there's no client in the transaction, the more than likely the for sale by owner, if they said they're willing to compensate you for bringing that buyer, the for sale by owner, the seller would sign a transaction brokerage agreement with you because they're the ones agreeing to pay you or compensate you. The buyer has not. Now, if that is split, if the seller wants to pay you and the buyer's going to pay you, you'd need to have a transaction brokerage agreement with both. But in that scenario, if the for sale by owner and the buyer is not paying anything, you would get a transaction brokerage agreement from the seller or for sale by owner. Now, on your own listing, you have a client in the transaction. I read there, the seller, your listing agreement is the one that obligates the seller to pay you once you bring a buyer. And if you write an offer for a buyer customer, you do not need a transaction brokerage agreement with that buyer, okay? So if you have that client and you have a buyer customer, you do not need a transaction brokerage agreement. If they're just a standard customer in South Carolina, obviously, I neglected to say this, you do obviously need to go over the South Carolina disclosure of brokerage relationships to find out whether they want to become a client or not. That's always, you have to do that. However, if they decide to be a customer, no need for a transaction brokerage agreement unless they're obligated to pay you. That's our policy. You go by what your broker's policy is, but that's ours. All right, number two, is it better to do dual agency or only have a customer relationship with the buyer on my own listing, Now listen, I'm going to answer that this way. This is agent to agent, the comfortableness of the agent. Are they comfortable doing dual agency or are they not? My personal opinion, my humble opinion, my professional opinion is that it is better to have the buyer as a customer and not perform dual agency, just because of the sheer liability that an agent can get themselves involved in with saying what they shouldn't to either party. Okay, remember, there's limited counsel and advice that you can give if you're in dual agency. Okay, so it's not wrong to do a dual. You can do it all day long in South Carolina. I just prefer to represent one party at a time, just because I don't want to have to deal with the liability and the problems knowing if I said something that I shouldn't have to the other party. I just want to steer clear of that. Okay, but again, not wrong. Probably better to have a customer, especially if it's your own transaction. Obviously, you're going to need to get the seller's permission for that. All right. We are at number one, the number one question I get asked. And I'm not going to give it to you right now, not right away, okay? Because if I were to ask you to guess, most of you would probably guess this question, okay? And if I gave you 3 guesses and I just said the first 2 don't count, you would still probably get it. Here it goes. The number one question that I get asked, here it is. Are you busy? Are you busy? It's that simple. Are you busy? When I'm called, when agents stop by the office, when I'm text message, it's, are you busy? Guess what? Doesn't matter. Yes, I'm busy. Of course. However, it doesn't matter. When you call or stop by, you become the most important matter in that moment. You. There is a movie that Tom Hanks played a character, and he was playing Mr. Rogers. It's called A Beautiful Day in Your Neighborhood. And he did a phenomenal job. And during this movie, Mr. Rogers was being interviewed by a writer by the name of Lloyd Vogel. And one time while Mr. Rogers and Lloyd were talking on the phone, Mr. Rogers asked Lloyd Vogel, do you know what the most important thing in the world is to me right now? And Lloyd obviously said no. And Mr. Rogers said, the most important thing to me in the world right now to me is talking to Lloyd Vogel. Okay? What Mr. Rogers did was he made Lloyd Vogel feel that his time, that he was special and nothing else was standing in the way. Mr. Rogers gave Lloyd Vogel his undivided attention. That's the broker that I want to be. That's the guy that I want to be. So yes, I'm busy. But when you call or stop by, you become the most important matter in that moment. Yeah, I just wanted to say thank you so much for tuning in and watching the top 10 questions that I get asked as a broker in charge. Hope you enjoyed that. Hope you got something out of it. And as always, I hope you have a wonderful, wonderful day. I hope to see you around the real estate corner, and hope we do some sort of transaction again very, very soon. As always, if you're not subscribed, click that subscribe button. If you like the video, click the like button. If you see that little bell, click on that little bell. And every time that there's a new video uploaded to YouTube, you will be notified. Until next time, friends, God bless each and every one of you. Have a fantastic day. Take care.